Um, my name is Christy Kimball. I'm a partner at Holland & Hart. I'm based out of their Salt Lake City office, but do work for companies throughout the Intermountain area and throughout the nation relative to regulatory compliance in the healthcare field. Joining me also today is Amber Ellis, who is of counsel with our firm. Amber has practiced law for 13 years, but she, for the most recent 5 years, has been in-house for a major hospital system, so has a lot of good, relevant knowledge of how some of these issues with Hipaa interact with the hospital system. So I'm pleased that she could join me today. With that, we'll go ahead and get started. I'm going to advance to the next slide. Let's see if I can. As always, we usually just have this disclaimer, just making sure that everybody that's listening to the call is aware that this program is designed to give general information to pertinent legal topics, and it's not intended to create an attorney-client relationship, nor is it meant to provide specific, legal, or financial advice for any of the participants. Here is Amber and I's information following this presentation. If there are any questions, any issues, please feel free to reach out to us, and we'd be happy to answer any questions that we can. With that, I'm going to go ahead and turn this over to Amber Ellis, who's going to be covering the first half of the presentation, and then I will jump in for the second half.
Thank you, Christy. So to get started, the Health Insurance Portability and Accountability Act, 1P, 2As, is comprised of the privacy rule, the security rule, the breach notification rule, and then the HITECH Act came in 2013, modified HIPAA, and implemented by the HIPAA Omnibus Rule. So HIPAA is the baseline for privacy regulations that apply to patient health records. HIPAA will preempt less restrictive law, but it does give room for more restrictive law to actually preempt HIPAA and take precedence in certain situations. And so that's going to include records that are covered by such laws as 42 CFR Part 2. So those records involved in a federally assisted drug and alcohol treatment program. And there may be other state laws additionally with respect to particularly sensitive records such as AIDS and HIV records, mental health, that may be covered by more restrictive laws. So pay attention to state laws in addition to HIPAA. It is just your baseline. It is very important to stay up to date on the HIPAA regulations. There are potential criminal penalties out there for knowing violations of the HIPAA law. And so they start at $50,000 fines and a year in prison, and they go up to, depending on the mens rea and the purposes behind these violations, $250,000. Fines and 10 years in prison. So it's really important to pay attention to these regulations. In addition to the potential criminal penalties, there are a number of civil penalties, and I think that we see a lot of enforcement actions, particularly in the last 12 months, giving rise to some of these civil penalties. And you can see here there is a gap between penalties that occur when conduct does not involve willful neglect. So you can see these penalties tend to be a little lower, and for both violations where the conduct was not known and should not have been known and yet resulted in a violation, if corrected within 30 days, there may be no penalty. And additionally, the OCR can waive or reduce the penalty. And the same is true for a violation that was caused by a reasonable cause. If those are corrected within 30 days, there may be no penalty. However, if conduct rises to the level of willful neglect, there is a mandatory penalty. So it'll be important to pay attention to some of the practices you can put into place to avoid getting your entity into a situation that could rise to the level of willful neglect. So here are some practices that you can keep in mind and put into place to avoid hitting the willful neglect threshold. So have required policies and safeguards in place, keep those up to date, review them regularly. Make sure that you execute business associate agreements. The failure to execute a business associate agreement can be a violation just on its face once that PHI changes hands. Be sure to train your personnel and document that training. Regular training and documentation shows that you are taking steps to avoid this willful neglect level of intent. In keeping with this training, make sure you respond immediately and mitigate and correct any violation. There are things you can do to correct these violations in this time frame that will keep you from some of those mandatory penalties. And this goes hand in hand with training. If your culture is one of openness and transparency with respect to any potential or suspected breaches, and those are communicated promptly to your privacy officer and investigated, you're going to be in the best position to correct violations and then timely report any breaches that are required. So enforcement, in addition to some of the self-reporting that we're going to discuss, the state attorney general can bring lawsuits. The HITECH Act actually includes some language that suggests it is possible to promulgate regulations for individuals to recover a percentage of penalties. That sounds a little bit like some of the whistleblower incentives that we have under other healthcare laws. That's not being done right now, but it's something that could be coming down the pipe eventually. HITECH's been in place for a while, and those rules haven't come through, but something to be aware of. And employees who violate HIPAA should be sanctioned. That's something you can cover in your policies. The type of violation and what level of sanction will be imposed is something you can cover in those policies and be sure to enforce uniformly across your employee workforce. Self-reporting of unsecured breaches of unsecured protected health information must be made to the affected individual, to the Department of Health and Human Services, and for those breaches that involve more than 500 persons, to the media. Now, HIPAA, standing alone, does not have a private cause of action. It does not provide for that. However, really creative plaintiffs' counsel can proceed with negligence or breach of implied contract lawsuits, depending on the exact facts giving rise to a HIPAA breach. At some point, HIPAA is almost a standard of care with respect to patient records. At least that's what some attorneys would like to argue. So although HIPAA in and of itself doesn't give rise to that cause of action, it doesn't preclude the possibility that creative attorneys could come up with some basis to allege liability. So what entities are subject to HIPAA? Covered entities, and these include not all healthcare providers, but certain healthcare providers, and it is those who engage in these electronic transactions. Additionally, health plans and employee group health plans with 50 or more participants or who are administered by a third party are covered entities under HIPAA, and then healthcare clearinghouses. Additionally, business associates of covered entities, so those entities who you share PHI with to perform services on your behalf. So you're going to have a lot of vendors for software, your EHR systems, and different types of services that folks are performing, billing, assistance with your records management, and things like that. Now, if you're not a covered entity, if you've had an opportunity to explore this and determine whether or not it applies to perhaps a small clinic, you might want to think about not holding yourself out as being, quote, HIPAA compliant. Obviously, any healthcare provider is going to comply with relevant privacy laws and the ethical rules with respect to the provider-patient relationship. But if you're not actually a covered entity, but avoid holding yourself out as being compliant with HIPAA, because HIPAA is about more than just protecting the privacy of a patient record. There are those security requirements and additional requirements that are above and beyond the basics that any provider will do based on those ethical obligations attendant to their license. So protected health information, any individually identified health information. So if it could be used to identify the individual, then it is individually identifiable. It also needs to concern the physical or mental health, healthcare, or payments. Billing records are going to be covered as well. If it's created or received by a covered entity in its capacity as a healthcare provider, and we'll talk a little bit more about healthcare providers and how they may function as employers as well. That's a separate function. They're not functioning in their capacity as a healthcare provider. And these can be maintained in any form: paper, electronic, microfiche, however you are maintaining this information. It doesn't matter what medium, it still can qualify as PHI. So what's not covered by HIPAA? So HIPAA does apply to the health records of deceased individuals. However, after the person has been deceased for 50 years, it's no longer covered by HIPAA. Information that is maintained in a capacity other than as a provider. So healthcare entities are going to have personnel records. Some of those personnel records may contain some health information, but if that information is only maintained for purposes of their employment, then it's not covered by HIPAA. Now you want to be careful, because some of your employees may also be patients of a covered entity. And so the information that is obtained from those individuals, those employees slash patients, if it comes into the possession of the covered entity by virtue of that person coming as a patient, that information should not be used for employment purposes. So you'll want to be really careful. Make sure that your employees are trained regarding those walls, and that if they have any questions, that they should reach out to the privacy officer before disclosing information that really needs to be kept separate as protected by HIPAA. Now, de-identified information is also not covered. And so if the identifiable information is removed to the extent that you cannot tell who the information is about, then it is de-identified. Now, this includes very obvious identifiers: names, dates of birth, social security numbers, but it additionally includes unique identifying numbers, characteristics, or codes. So you want to be really cognizant of what pieces of information would allow someone to identify who the patient is, and remove that for it to qualify as being de-identified. So HIPAA prohibits the unauthorized use, access, or disclosure of PHI unless HIPAA either permits or requires it, or the covered entity has the patient's or the patient's personal representative's authorization. And authorization has a very specific meaning under HIPAA. I occasionally hear folks interchange the words consent, authorization, release. For purposes of HIPAA, authorization is a particular type of documentation, and we'll talk about that a little further on. So these uses, access, and disclosures are going to apply to the unauthorized disclosure outside the covered entity, the unauthorized use within a covered entity, and the unauthorized access from within or outside the covered entity. And so this is one of the points where it's important to train your workforce that if you have a VIP or celebrity patient, it's a need to know basis. Only those folks who are actually treating that patient have access to the record. Just because you're part of a covered entity does not mean that there's free access to those records. It needs to be kept to authorized and necessary uses. So don't access the PHI if you don't need to know it. Don't disclose the information unless it fits under an exception or you have a patient or personal representative authorization, and then make sure you implement reasonable safeguards. And we'll talk about all of those a little later on. So you may use PHI without a patient's authorization. This is one of the exceptions for your own covered entity's treatment, payment, or healthcare operations. So you don't have to call the patient every time you need to use the information to get their imaging sessions scheduled or have those images reviewed, those treatment operations can be performed without calling the patient at every step of the process. You may also disclose PHI to another covered entity for that entity's treatment or payment. So if you're referring a patient to another provider, a specialist perhaps, the necessary PHI, the minimum necessary, and we'll talk about that a little later on too, can be disclosed for purposes of that treatment. It can also be disclosed to another covered entity for that other entity's payment and for certain healthcare operations if both of the covered entities have a relationship with the patient. So for any of those healthcare operations, you're going to want to double check and make sure that both entities have a relationship with that patient. Now, an exception is psychotherapy notes. Those require specific authorization for use or disclosure to others. However, it's important to remember that the definition for psychotherapy notes does not extend to all mental health records. Psychotherapy notes is very carefully defined as those notes that are used by the provider for the provider's own use and are kept separate from the rest of the medical records. There have been a number of enforcement actions this past year that involved mental health clinics refusing to turn over psychotherapy notes under the belief that this exception allowed them to be withheld. And that is not the case. Psychotherapy notes are carefully defined. So before refusing to turn those over, make sure that they fit the definition for psychotherapy notes under the rule. Again, if you agree with the patient to limit the use or disclosure for treatment, payment, or healthcare operations, then you have to abide by that agreement unless there's an emergency. It's really difficult to keep track of one-off agreements with patients. And so as a general rule, I would say don't agree to limit the disclosures for treatment, payment, or operations. And be careful about specifically asking a patient for a list of persons to whom disclosure can be made. That could create an inference that other disclosures won't be made to other people. If there is a legitimate reason that you do need to have a list of emergency contacts or something like that, make sure that the patient understands that there are still circumstances that may permit disclosure to others under Hipaa that are consistent with that law. You can use or disclose PHI to family or others who are involved in the patient's care or payment for care. And if the patient is present, you can disclose if the patient agrees to disclosure and does have that chance to object and doesn't object. And there are circumstances where it is reasonable to infer that you have the patient's agreement just based on the circumstances. So if a patient comes into your clinic and they have a family member with them, and when they are transferred to the exam room, they bring that family member with them, it is reasonable to infer that the patient is agreeable to having certain PHI with respect to that appointment shared with that family member. Now, there may be situations where the patient cannot agree, emergency situations perhaps, and it's still permissible to disclose information to a family member or another person involved in that patient's care, a friend who brings them to the emergency room perhaps, if the patient hasn't objected and the provider determines that it's in the best interest of the patient. You want to limit that disclosure to the scope of the person's involvement. You likely don't want to delve into historic medical records with respect to the patient unless it's directly relevant to the patient's care at that time. So perhaps if the patient had a bad reaction to certain medications several years ago, if there's a decision being made about what medication to use today, that old information may be relevant. However, you'll want to make sure that that scope is limited in these situations. And these same concepts apply to disclosures that are made after the patient is deceased as well. So facility directories, you can put some limited information in a facility directory regarding the PHI. You'll want to make sure it's limited to what the rules permit, but that is an option. There are a number of exceptions to Hipaa for public health or government functions. And so if another law requires disclosure, you may disclose PHI. If a disclosure is necessary to prevent serious and imminent harm, you may also disclose that PHI. And so these may come up where you have a situation of abuse. Some states have laws with respect to certain types of injury need to be reported. So those are things to be aware of on a state-by-state basis. Additionally, public health activities and health oversight activities may have some reporting requirements. Judicial or administrative proceedings have a number of exceptions. So if a court orders you to provide certain PHI through either a court order or a warrant or a grand jury subpoena, any of those are permissive disclosures under Hipaa, and you can share that PHI because a court has ordered that disclosure. Similarly, subpoenas, if they're accompanied by a court order or written satisfactory assurances that the patient has been notified that these records are being requested and given an opportunity to object to their production and a reasonable period of time to do so, those may also be disclosed. But you'll want to look at those specific regulatory requirements to make sure all your I's are dotted and T's are crossed before making some of those disclosures. So law enforcement, there are some cases where there are specific requirements to turn information over to law enforcement. You may have a fugitive situation. Hipaa has specific pieces of information that can be given to law enforcement when they are seeking a fugitive, for example. And then workers' compensation also has some exceptions that allow the disclosure of PHI. So patients have a right of access of their medical record, and they also have the right to request that such PHI be delivered to a third party. And I have seen this come up most frequently in situations where patients counsel in perhaps a personal injury case want to obtain a large quantity of a patient's PHI. And so I think that this may have arisen in part out of a desire to limit the charges that were charged to produce these records. So there originally was a belief, and there were OCR rules that stated if the patient requested that the PHI is sent to a third party, there were limits to how much should be charged. However, in January 2020, a case, Ciox, was a party to that case, came down that made it clear that if, number one, there's a distinction between ePHI and PHI. And number two, when it's being sent to a third party, those fees are not limited to that reasonable cost-based fee, the patient rate. And so the other piece that's important is for ePHI, those responses must be made within 30 days. And that is not the case for PHI, which I think this is helpful for covered entities because occasionally when you get a request for information going back to 20 years or so of a patient's record, you're going to have some PHI in media that are not as easy to access, and you have to spend quite a bit of time and employee power to put these in a form that can actually be provided to the patient or a third party. And so when other PHI is requested that is not ePHI, it is optional. If you're asking, or if the patient's asking that it be given to a third party, it's optional whether or not that is actually done because it is not required under this new rule. If it's ePHI, it is required, but it's not subject to that lower patient rate. So an authorization must be obtained in order to disclose psychotherapy notes, in order to engage in marketing, to sell PHI, research, and for all other uses or disclosures, unless one of the regulatory exceptions that we discussed above applies, or if there's state-specific law requiring that. And you'll want to look at the specific required elements of an authorization. We're not going to spend a lot of time on that today. You can look it up on the HHS website. But one other fact, the authorization cannot be combined with other types of release documents or forms or a medical consent, for example. It's a standalone document. So employment physicals, IMEs, drug tests, HIPAA still applies to these situations. However, there are a couple of differences with respect to how those authorization forms are set up. You do need to obtain the patient's authorization to disclose an employment physical, for example, to an employer before that service is provided. And the provider may condition that exam on authorization. Now, typically that's not the case. Typically, the signing of an authorization is not something that an exam is conditioned on. However, where the purpose of this exam is for employment purposes, that conditional authorization is permissible. And additionally, the employer can condition employment on the signing of that authorization. So we get back to situations where a covered entity is also an employer. It is very important to keep those files separate. The employee file, even if it contains some information that otherwise would be protected health information and subject to the laws of HIPAA, in that personnel file as opposed to their patient file, and don't share information between the two. So there may be some exceptions. Again, if a disclosure is to avoid serious and imminent threat of harm, but I will look at these on a case-by-case basis, work with your legal counsel, and work with your privacy officer on those items. So marketing, you'll want to be really careful about engaging in marketing. There is an exception for when you need when you don't need an authorization, and that is if you are describing a product that you as a covered entity, product or service that you provide, that is for treatment of the patient, that's for case management, care coordination. In those circumstances, you would not need to get an authorization unless the covered entity is also receiving remuneration from a third party. So think about those and make sure that you're covering your bases if there are any marketing disclosures being made. You cannot sell PHI unless the patient's prior written authorization indicates that the covered entity will be receiving remuneration. And that's going to include direct and indirect remuneration, financial and in kind. This ties in with the information blocking rule as well. This concept may apply in situations where excessive fees are charged to the patient to copy or produce records. So that is a very similar concept to what we're seeing in the information blocking rule, which comes into effect in April. Both of those sets of regulations make it a violation to be charging excessive fees. So you'll want to be careful about those situations. So personal representatives. Under HIPAA, you will treat the personal representative as if they're the patient. They stand in the shoes of the patient. They can exercise the same rights as the patient. So who is the personal representative? You have to look to state law to determine who that is. So the answer to that question may vary state to state. Generally, it's the person who can make healthcare decisions for the patients, or in the event that the patient is deceased, make decisions for that patient's estate. So as an example, in Idaho, personal representatives will include the court-appointed guardian, an agent on a durable power of attorney, spouse, adult child, parent, someone to whom a delegation of parental authority has been issued by the parent, another appropriate relative, and then there's a catch-all, any other person responsible for patient care. Now, in the event of divorced parents, generally speaking, unless one of the parents' rights have been terminated by a court. Now, this doesn't mean they're not custodial parent, it means their rights have been terminated. That parent has the right to make medical decisions for their child and is thus entitled to request information under HIPAA. Idaho additionally has a specific law that states that a non-custodial parent is entitled to access information. But if the custodial parent has requested that that custodial parent's contact information, address information, etc., is redacted, that the covered entity needs to do that. This does not mean that one parent or the other has the ability to veto the other parent's rights. I know that there are sometimes situations where one parent, they know and realize that they have the right to request the minor child's medical records, and they want to control who else can access the medical record. And so one example of that is a parent who does not wish the other parent's new spouse to have any involvement with the child's care. Well, if the mother does not want the new stepmother to have the ability to take the patient into the clinic, that is not something that the concept of personal representative authorizes. The mother can access the record, and the father, if he chooses to delegate parental authority to his new wife so that she might, for example, bring the child in for a clinic appointment, he has the right to do so. There's not a veto power that is associated with this. Now, there are some situations where a covered entity is not required to treat someone as a personal representative. This might be if the minor actually has authority to consent to their own care. So that's going to depend on each state's law. If a minor is obtaining care at the direction of a court, again, a court-ordered judicial bypass for certain types of procedures or care, the parent may not be able to be the personal representative in such cases. The parent agrees that a provider may have a confidential relationship, such as a teenager who wants counseling, and the parent says, I would like this to be confidential. Such situation would allow the covered entity to not treat that parent as a personal representative for purposes of those records. And then finally, if the provider determines, and I want to highlight this, the provider, it's not a records professional or an administrator. If the provider determines that treating this particular personal representative as the patient in the circumstances is not in the best interest of the patient, then the covered entity is not required to do so. So I think an example of this would be situations of child abuse or alleged child abuse. You might also look at the existence of a no contact order or protective order between the minor patient and the parent or other person who is asking to be treated as a personal representative. Those are situations that are at least a red flag that the provider should take a look at this request and decide whether or not it's actually in the best interest of the patient to treat that person as the personal representative and provide them with the records. So things to think about when you're examining requests for records. And then I just wanted to point you to a resource on the website of the Department of Health and Human Services. They have a number of great resources, but this one in particular is a guide with some examples and common questions with respect to communicating with a patient's family, friends, and others. And this is a really useful guide that you can take a look at and share with folks on your staff to make sure that everyone has a good understanding of how these rules work in the day-to-day management of the practice of a covered entity. And so with that, I will turn it over to Christy.
Thank you, Amber. That was such helpful information. Before I get started moving into HIPAA related to business associates, just wanted to mention that throughout this presentation, when we discuss, let's say, like Idaho specific statutes or laws, those are just examples. We recognize, Holland and Hart is in, 8 states and in Washington, D.C., but we also help clients, with outside of those states. So we're just giving those as examples, and we want to make sure that in your, all of your minds as we're going through this, you think about where there may be state-specific laws that are going to, alter or make these requirements a little more stringent. And so you also always have to be thinking about what state laws are going to be layered on top of HIPAA that you're going to have to comply with. Moving on from here, let's move now into discussing business associates. I am going to skip to the next slide quickly and then move back to slide 29. In regard to business associates, I'm sure most of you are familiar, obviously, with what that is, but just to be really clear about that, a business associate under HIPAA These are entities that create, receive, maintain, or transmit PHI on behalf of a covered entity. They can be covered entities sometimes. They're actually acting as business associates. There can be relationships, right, where sometimes an entity in one regard is a covered entity, but then maybe acting as a business associate in another relationship. So oftentimes as healthcare attorneys, when we're called to, we're asked to look at a situation, sometimes depending upon the scenario and who we're contracting with, it can be a little complicated where we have to really think through, who's acting as who in this scenario, and what are the respective roles and responsibilities. Also, this includes subcontractors of business associates. So you have to think about, if I'm a business associate, let's say that I'm electronic health records company. Obviously, I act as a business associate to a covered entity in that regard. But there are lots of times, and certainly almost every business associate, they have downward stream contractors that are not part of their workforce, but they are independent contractors that they're contracting with, whether that be for, let's say, software that they're utilizing, and that software provider is going to be getting access to PHI, whether it could be, let's say I have tech companies where they're hiring software developers to help them develop out more of their products, and those people will have access to the databases that contain PHI. All those downward stream vendors that are going to be having access, if they're going to create, receive, maintain, or transmit PHI for that business associate, again, on behalf of that upward stream covered entity, we're going to need a business associate agreement in place with that downward stream contractor. So in terms of business associate agreements, they must contain required terms and statements that under Hipaa are required. Two of those main things are to identify permissible uses, and then ensure that the limits that business associate has under their agreements with the covered entity are contained in any downward stream contracts that business associate has. So you've got to make sure that whatever that business associate agreement between a covered entity and their business associate, whatever substantive terms and conditions are therein, you're always going to have to make sure that any downward stream vendors, contractors, that their business associate agreements also contain those substantive terms, and bind those downward stream people to what the upward stream people are bound to. I'm going to go back to the slide 29 quickly on this. But in terms of business associate agreements, you can disclose PHI to business associates if you've got a valid business associate agreement in place. Failure to execute a BAA is a Hipaa violation. You've got to have written, signed business associate agreements in place, or it is a Hipaa violation, and that could subject you to Hipaa fines. A couple of examples here. There was a recent settlement where a covered entity gave records to a storage company without a BAA in place, and it was a $31,000 fine that covered entity received. Also, you have to think about, based on recent settlements, a covered entity could be exposed to liability for the conduct of their business associate. Another couple of examples are a covered entity that turned over x-rays to a vendor. There was no BAA in place, a $750,000 fine. In another situation, there was a business associate whose laptop, right? We had an employee of a business associate. Their laptop was stolen. There was no BAA in place between the business associate and the covered entity, and there was a substantial fine, as you can see there. So you've got to make sure that if you're contracting with business associates, you want to make sure that you do some due diligence to make sure that not only do you have a business, you've got to make sure you've got a business associate agreement in place. It's just critical, or else the covered entity, could be fined substantially. But the next step is really do some due diligence and vetting of that business associate to ensure that they are, that they have their policies and procedures in place to ensure that the risk of Hipaa breaches are minimal with that BAA, with that business associate. So now skipping to 31, we've included a link here. The Health and Human Services does have, again, some great resources. And I would, as you saw before in the portion of the talk that Amber gave, the government has some great resources. And if you're ever looking for resources, that is a great place to start, because they've done a good job really trying to assist covered entities and business associates navigate through these issues. But they do have, that we've included the link here, where they have sample business associate agreements so that you can utilize and then take and with your legal counsel and modify. Also, I can tell you with Holland and Hart that we've got, depending upon whether or not you're the covered entity, whether you're the business associate, and what direction these agreements are going, as attorneys for these entities, if we're representing a covered entity, we will make that business associate agreement more robust and make it more onerous than what HIPAA would otherwise require to better protect our covered entity client. If we're representing a business associate, and let's say there's certain situations where we'll be drafting a model business associate agreement for, let's say, a tech client that's a business associate that they're going to try and get the covered entities to sign. But if that's our client, then we would be making a template for them that is a little less onerous, still complies with HIPAA, but does not create additional burdens that aren't required by HIPAA. So you want to make sure that based upon the needs and the situation, that you have these business associate agreements in place that are, most appropriate and protective of your entity and your company. So let's talk about the liability for acts of business associates or subcontractors. In a situation where a covered entity or a business associate knows that a business associate or a subcontractor is violating HIPAA and they fail to take action to end the violation or terminate the BAA, that can lead to substantial fines and penalties under HIPAA. So you want to make sure that if you have some awareness or concerns or knowledge that there's been a violation, that you investigate and take action. And if it's not remedied, that you do terminate the BAA and the relationship. The other thing is that you want to make sure, in terms of liability, make sure that with the subcontractors or the business associates, depending upon who it is that you're dealing with these business associate agreements, you want to make sure that that downward stream entity, that if we look at this test of whether or not they're acting as an agent of you, that while they are, you want to make sure that you're maintaining that independent contractor status, that based upon the language of the contract and then your control over that downward stream vendor, that you don't have the level of control that a court would find that they're not acting as an independent contractor, but really that they are an agent of you, because that will create more liability for you. So you want to make sure that with these downward stream vendors, these business associates, that you can ensure as much as possible that you're remaining independent contractor status between the parties and therefore mitigating potential liability. In terms of verification of when you're being asked to disclose PHI, just some general guidance about how to handle that. Before you disclose PHI to someone that's requesting information, as a general rule of thumb, you should verify the identity and authority of the person requesting that information if you do not know them. You can ask for a social security number, birth date of a patient, badge, credentials, etc. But if you do not know the person that it is who they say they are in their relationship to the patient, you should get some credentials and verify their identity. Obtain any documents, representations, or statements required to make the disclosure. So for example, written satisfactory assurances accompanying a subpoena, representations from police that they need info for immediate identification purposes. Oftentimes, as hospital counsel, I will get phone calls saying, we've got law enforcement here, they're saying that they've got a warrant, or they're saying that they've got the subpoena and it requires us to do X, Y, and Z. oftentimes those situations can be a little nerve-wracking and people are a little, scared, and sometimes they can feel intimidated. But often, we'll just kind of calm the situation down and say, no problem. Can you get a copy of the warrant, or the subpoena? Can you send that to me? And often when we slow down, we just need to get a copy of that and see what is it actually requesting? What is a judge said that we need to do here if it's for a warrant? And we follow that very specifically, but you want to get copies of those things and keep them on file to document why there was the disclosure of PHI in response to something, right? So get those documents, keep them on file so that you can show, why you did disclose the PHI that you did. In terms of portals, let's say these are patient portals, portals in EMR, any kind of healthcare tech software. You want to make sure that there's appropriate access controls therein. Earlier, Amber talked about, for example, celebrity patients at a hospital. There is kind of one more than not famous case out of LA where you had hospital employees at a hospital in LA where a lot of celebrities, would go to get treated, where it was found that you had, nurses and employees of the hospital that really had no business looking up the medical records for these celebrities who were getting in there just to be nosy, wanting to see why these celebrities were in the hospital. I'm giving you that example because in all aspects, your organization, not everybody needs, carte blanche access to patient information. You should ensure that your access, however, we're talking about whatever kind of organization you are and whatever kind of PHI that you hold, that you should assess who needs access to what PHI, what's appropriate, and that you have different levels of access according to the appropriate needs of that particular individual. And you should have processes whereby you can audit, access to make sure that people aren't inappropriately accessing information that they shouldn't be accessing, and ways to kind of trigger when employees change, when they change positions, when they leave employment, that you immediately, stop their ability to access information. In regard to the minimum necessary standards, specifically, you want to make sure in general, there's usually this minimum necessary standard with HIPAA. It doesn't always apply, but in most circumstances it does. But you shouldn't use or disclose more PHI than is reasonably necessary for the intended purpose. However, this minimum necessary standard does not apply to disclosures to the patient. Of course, they're the patient. You can give them all the relevant information that they're wanting. The provider for treatment, if it's regarding treatment, the providers need all information to be able to decide these treatment decisions. Per the individual's authorization, let's say that that's an authorization for release of PHI where they've designated, some kind of friend or family or another physician that they're saying, please give, all of my, records. So obviously you do what they're asking you to do, or as required by law, right? Sometimes there'll be, let's say, a subpoena and you've just got to follow that subpoena. You may rely on the judgment of another covered entity, a professional within the covered entity, a business associate for professional services, or a public official for permitted disclosure. Okay. In terms of the minimum necessary standard, your organization should adopt policies that address the internal uses of PHI. Again, it's what I said before, identify persons who need access, draft policies to limit access accordingly. You should have policies that address the external disclosures of PHI. What are the routine disclosures, established policies, non-routine disclosures? There should be a case-by-case review for the specific fact pattern and what should happen in those cases. And the same goes for requests for PHI. Moving to the HIPAA security rule, every organization, whether you're a covered entity, a business associate, downward stream vendor, if you are subject to HIPAA, every entity needs to do a risk assessment. That is part of, that's part of the requirements of HIPAA. And if you have not done a risk assessment and there's a breach, that is when you're going to see far more punitive measures taken by the Office of Civil Rights than not, because it just shows like a willful disregard for even caring about the risk that your organization may pose to the PHI that's in your possession. So under that HIPAA security rule, you've got to do a risk assessment. Again, the government has some great tools on that. If you look online under HHS's website for a risk assessment, where you can go through and do your own risk assessment. You don't need to hire a third party to do that if you'll just take the time to go through and follow that. Thereafter, you've got to implement safeguards, and those are administrative, technical, including encryption, and physical safeguards. And you've got to make sure that you have the appropriate executed business associate agreements in place. So overall, those are intended to protect this electronic protected health information, the confidentiality, integrity, and availability of such. And that should really be the guiding principles that you think of as you move through that. Again, we've included here just showing you this security risk assessment tool that the government's put out that you can utilize to help take you through that. In each of these areas that we just mentioned, the administrative safeguards, physical safeguards, technical safeguards, those are the three areas as you do the risk assessment that you're going to be thinking of. And there's certain applicable standards. And then you need to think about on certain of those, there are required, safeguards, and there are things that are addressable. And you're going to look through and say, okay, what does our organization, what are kind of the highest risk issues? What are the specifications we have to get in place no matter what? And then some of these other things that are identified, sometimes there may still be risk, but you need to be addressing the highest risk and those things that you can easily address. The government does understand that, let's say, a little solo healthcare practitioner has a lot more means, money, sophistication. They have a lot less than, of course, a hospital system. So they don't expect that solo practitioner to be able to take the same measures and have the same, necessary safeguards in place, technology in place that maybe a sophisticated hospital system has in place. But they do expect that you go through that risk assessment, implement, what's required, and then implement what you can according to the level of risk that you can address. Again, we're just pointing you to HHS's website and the URL that you can follow to get security rule guidance material. Here's other information again that we're just pointing you to so that you can utilize that on your own. In terms of encryption, encryption is an addressable standard in HIPAA. And the standard says that you need to implement technical security measures to guard against unauthorized access to ePHI that is being transmitted over an electronic communications network. And then in terms of what's addressable, implement a mechanism to encrypt electronic protected health information whenever deemed appropriate. So you can see there, it's not telling you, here's the standard, and it's saying, here's, how we're just telling you to address it, but it's not specific. It's not saying you must do this type of encryption, this way, and it's not saying to what, all information that has to be done. It's talking about if it's transmitted over electronic communications, then you've got to implement some kind of technical security measures. And if you look at below, it's talking about that encryption, that's wherever it's deemed appropriate. So there's a lot of latitude for people to really decide how to, put this in place in a way that's appropriate for their organization. One thing to note is that when your ePHI is properly encrypted, it's considered secured under HIPAA. So if there was a breach, for example, let's say a laptop was stolen, but the data, the ePHI, was properly encrypted, that would not be subject to breach reporting because anything that's encrypted is considered secured under the law. OCR does presume that the loss of an unencrypted laptop, USB, or mobile device constitutes a breach. So you should really be thinking about that and doing everything that you can to get your devices encrypted. Here's again, we're just pointing you to another resource with the government about mobile devices. and health information privacy and security. You know, the government has put out some really helpful resources about that. But nowadays, where everybody pretty much has a smartphone, you want to be thinking about those devices and how to make sure that if those are stolen, if an employee leaves, are those devices, let's say the apps that they have access to PHI on those, are those encrypted? Are they a separate app that there is verification of the individual that was supposed to have access to that app on the phone, where there's some layers of protection before anyone could even get in to see the ePHI? So you just want to be thinking through those things when it comes to mobile phones. And again, go to healthit.gov and there's some helpful resources there for you. This is a hot topic and we get a lot of questions about this, but communicating by email or text. The general rule is that communication, the methods for doing that, it must be secure, and that is encrypted. By its very nature, you know, text messaging is not encrypted, right? So text messaging is not secure, but you may communicate with patients via unsecure email or text if you've warned the patient and they choose to receive it in that unsecure manner. So normally in that situation, you know, we'll draft, you know, language on, like, say, patient intake forms where, you know, patients can elect, where they can say, I understand that receiving communication regarding my health and my health records via email or via text is not secure. However, I wish, you know, for the physician or for your office to communicate with me via that method. You need something where they're documenting in writing that they're requesting that. When it comes to providers, staff, or other third parties, you must use secure platforms. There's not the carve out for that. So that's why you normally see that there are these apps, even on, let's say, providers' phones. If hospital systems have set up systems whereby hospital staff can communicate with each other via, it seems like, you know, text, but it's not. It's through these applications that are on their phones that have these security features therein, where it's not going to be versus just straight over SMS texting. Know also that when it comes to orders, that Medicare conditions of participation and conditions for coverage generally prohibit texting of orders. So you can't send, you know, the nurse or somebody else and say, hey, do X, Y, and Z via text. That's not going to be acceptable. So we just want to make sure you're aware of that. Patient rights, I think almost everybody, you know, should really be aware of these, but you've got to do a notice of privacy practices that has to be available to patients. The patients can request restrictions on the use or disclosure of their information. They have the right to receive communications by alternative means, i.e., you know, they could via text or via email. They can, they have the right to access their information, to amend, to review their information and amend it, and the accounting of the disclosures of their PHI to third parties. Again, we're pointing you to some helpful information at the HHS website. Administrative requirements, when we're going through, you know, HIPAA and these three areas for requirements, you know, under the security features, security and privacy, you need to designate a HIPAA privacy and security officer. You need to implement policies and safeguards. You've got to train your workforce. You've got to respond to complaints, mitigate violations, and you need to maintain documents for 6 years. So under HIPAA, those are your requirements under the administrative requirements. Quickly, because we're running out of time, on breach notification, if there is a breach of unsecured PHI, the covered entity must notify each individual whose unsecured PHI has been or reasonably believed to have been accessed, acquired, used, or disclosed. You've also got to notify HHS, and if the breach involves more than 500 persons in a state, you need to notify the local media. And the business associate must notify the covered entity if they're the ones where this breach occurred. Just going through breach of unsecured PHI, that is the acquisition, access, use, or disclosure of PHI in violation of the privacy rule. is presumed to be a breach unless the covered entity or business associate demonstrates that there's a low probability that the information has been compromised based on a risk assessment of the following factors. So you can go through those and look at these factors, but I will tell you that oftentimes we will have clients call us and say, this is what's happened. Let's say there was a glitch in our software. Some customers were able to see PHI of other customers or of our covered entities for a brief time. We go through and we do this analysis based upon these factors. And there are times where we can say, based upon the facts, we think that there is a very low probability that the information has been compromised. And therefore, we can consider it not to be a breach. But in those situations, you really should get legal involved to do that formal analysis and get something in writing that based on our analysis, we found that the probability was low, and under the breach rules for Hipaa, that it does not constitute a breach. I'm going to skip this because we're low on time. But just know that with a breach, you've got to give notice to the individual within a certain time period, and it has to be done in a certain manner. You've got to submit that breach to HHS. Normally, you would want to get your legal involved in drafting that breach notification. Here's an example of going to HHS's website on how to submit that notice of a breach. And you can actually look and see, everybody that has submitted, that they do post a list of breaches that are under investigation. So if you ever wanted to look at that, you can actually look at that. There's just some more rules. You'll also want to look, there are applicable state laws that could apply. So you'll want to make sure that you talk to legal counsel to see if there are any state laws that may apply in relationship to that breach. Sometimes if it involves certain data that's not just PHI, but that could be sensitive data such as banking information, other information, there could be other applicable rules, federal laws that are affected. So you would want to talk to legal counsel about that. Again, we just mentioned that there are these state-specific statutes that can be applicable, so make sure to talk with counsel about state-specific laws. The last thing, and then we'll close up, is that the proposed Hipaa modifications, there are some proposals to modify. These are not in place yet, but we want to give you a heads up about some possible changes that could be coming down the road. A proposed regulation that there is one that will shorten the time frame for responding to a request from patients for their PHI, and it would go from 30 days to 15. So if that happens, you'll need to respond a little more quickly to patients. Also, a proposal that gives patients a right to direct a covered entity to submit a request for ePHI to another covered entity. So it will give patients, right, the patient's going to be directing one, let's say, healthcare provider to submit information directly to another healthcare provider or insurance company, another covered entity for the PHI. And another proposal that will expand where this minimum necessary is not required. So it will lift that minimum necessary restriction on other areas besides the ones we've already talked about, to social services agency, community-based organizations, and home and community-based service providers. So please be aware of that. I do see that there are a few questions, and I know that we're over our time, but if you'll email us, we're happy to go ahead and answer those questions. In regard to the slides, someone's asking about the availability of the slides for future reference. I do understand, I believe that these slides, will be, there's a link that will be sent to all the participants so they can access those. And then these slides will also be on our website. We have a healthcare website at Holland & Hart and a healthcare blog, and these will be available there as well. So you should all have access to those in a very easy format. We'll make sure that everybody gets a copy of those and you've got access to them. With that, thank you so much for your participation. Again, please feel free to reach out to Amber and I with any questions. We apologize we were short on time, Would be happy to answer any follow-up questions via email. Thank you so much, everybody.